Okay, welcome back. I just want to remind you about some breaking news on our watch. 4 former senior government officials have been arrested for their alleged involvement in tender irregularities believed to have taken place at the Gauteng Health Department in 2007. They allegedly received kickbacks after awarding a massive contract to a private company. This is suspected to have been done without them following due tender procedures. Our reporter Senekal is at court. She'll bring us the latest very soon. Now, the 2 men accused of murdering 21-year-old farm manager Brendin Horner will know if they will be released on bail. Today, the magistrate is currently delivering that judgment with regards to the bail application. Let's take you back there now live.
That concluded the evidence before me. Both the legal representatives for the applicants as well as the legal representative of the respondent or the state address the court on the question whether exceptional circumstances exist, whether it would be the interest of justice to permit the two having evidence before me. I am satisfied that in respect of count 1, the accused are charged with an offence that falls under Schedule 6, and in respect of count 2, that the offence falls under Schedule 5 of the Criminal Procedure Act number 51 of 1977. Now, Section 60, subsection 11 of the Criminal Procedure Act states, and I quote, "Notwithstanding any provision of this Act, when an accused is charged with an offence referred to, subsection A, in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduce evidence which satisfies the court that exceptional circumstances exist which, in the interest of justice, permits his or her release." Subsection B, in Schedule 5, but not in Schedule 6, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interest of justice permits his or her release. Now, in S versus Lamini, S versus Larla and others, S versus Hubert, S versus Skitterkat, 1999, Volume 2, SACR 51, capital CC, Constitutional Court, Judge Kriegler, at page 85, paragraph 65, explain the difference between the subsection A and B as follows. I quote, "An accused person must satisfy a magistrate that the interest of justice permits his or her release. It clearly places an onus upon the accused to adduce evidence. However, apart from that, the exercise to determine whether bail should be granted is no different to that provided for in subsection 60, subsection 4 to 9, or required by section 35, subsection 1F. It is clear that an accused on a Schedule 5 offence will be granted bail if he or she can show merely that the interest of justice permits such grant. The additional requirement of exceptional circumstances imposed by section 60, subsection 11, paragraph A is absent. A bail application under section 60, subsection 11, paragraph A is more gravely invasive of the accused's personal liberty right than under section 60, subsection 11, paragraph B. To the extent, therefore, that the test for bail established by section 60, subsection 11A is more rigorous than that contemplated by section 35, subsection 1, paragraph F of the Constitution. It limits the constitutional right, close quotation. The term exceptional circumstances is not defined. What would constitute exceptional circumstances in a particular application for bail will depend on the facts of that case. In S versus Lamini, Ladla, Hubert, and Skitterkat, Supra, at page 89, E, paragraph 76, Judge Kriegler stated, I quote, "Likewise, I do not agree that because of the wide variety of ordinary circumstances enumerated in subsections 4 to 9, it is virtually impossible to imagine what would constitute exceptional circumstances, and that the prospects of their existing are negligible. In requiring that the circumstances prove to be exceptional, the subsection does not say there must be circumstances above and beyond and generically different from those enumerated." Close quotation. In S versus Brainkies, 2003, Volume 2, SACR 575 SCA at page 577, it was stated as the following was said, I quote, "What is exceptional cannot be defined in isolation from the relevant facts. Safe to say that the legislature clearly had in mind circumstances which remove the applicant from the ordinary run and which serve at least to mitigate the serious limitation of freedom which the legislature has attached to the commission of a Schedule 6 offence." Close quotation. In S versus Jonas, 1998, Volume 2, SACR 673 E at 687, paragraph E to J, Acting Judge Horn held that exceptional circumstances established when an accused person is able to adduce acceptable evidence that the case against him is non-existent or subject to serious doubt. The learned judge further stated, and I quote, "To my mind, to incarcerate an innocent person for an offence which he did not commit could also be viewed as an exceptional circumstance. Where a man is charged with the commission of a Schedule 6 offence when everything points to the fact that he could not have committed the offence. Example, he has a cast iron alibi. This would likewise constitute an exceptional circumstance." Close quotation. It is therefore clear upon a reading of the section as well as the authorities I cited that the onus is on the applicant facing a Schedule 6 offence to adduce evidence to the satisfaction of the court the existence of exceptional circumstances which is of such a nature as to permit his or her release on bail. Now this onus can be discharged on a balance of probabilities. See S versus Rudolph, 2010, Volume 1, SACR 262 SCA at 266, paragraphs F to G in this regard. Now, proof of exceptional circumstances does not automatically lead to the release of an applicant on bail. The court must also be satisfied that the release of the applicant is in the interest of justice. When considering the question whether the interest of justice permits the release of the applicant on bail, the court will have to strike a balance between the interest of the state as set out in subsections 4 on the one hand and the interest of the applicant to his or her personal freedom as set out in subsection 9 on the other. Now, section 60, subsection 4 provides, I quote, "The interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established, i.e., where there is a likelihood that the accused, if he or she is released on bail, will endanger the safety of the public or any particular person, or will commit a Schedule 1 offense. Or B, where there is a likelihood that the accused, if he or she were released on bail, will attempt to evade his or her trial. Or C, where there is a likelihood that the accused, if he or she were released on bail, will attempt to influence or intimidate witnesses, or to conceal or destroy evidence. Or D, where there is a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives or the proper functioning of the criminal justice system, including the bail system. E, where, in exceptional circumstances, there is a likelihood that the release of the accused will disturb the public peace or undermine the public peace or security. Close quotation. Section 60, subsection 9 provides A, in considering the question in subsection 4, the court shall decide the matter by weighing the interest of justice against the rights of the accused to his or her personal freedom, and in particular, the prejudice he or she is likely to suffer if he or she were to be detained in custody, taking into account, where applicable, the following factors. A, the period for which the accused has already been in custody since his or her arrest. C, the reason for the delay in the disposal or conclusion of the trial, and any fault on the part of the accused with regard to such delay. D, any impediment to the preparation of the accused's defense, or any delay in obtaining legal representation which may be brought about by the detention of the accused. E, the state of health of the accused. F, any other factor which, in the opinion of the court, should be taken. Close quotation. Now, with these principles in mind, the court will now proceed to evaluate the evidence tendered during the bail application. And for reasons that will become apparent later, I find it prudent to deal with the position of applicant number 2 first. The investigating officer, Captain Maybach, opposed the release on bail of applicant number 2 on the grounds that he posed a flight risk, that he will interfere or intimidate the state witnesses. He further opposed the release of the accused on bail, in that the 2 applicants pose a flight risk, and that his release on bail will disturb the public order or undermine the public order, or undermine the public peace, rather. The state's argument that applicant number 2 is a flight risk rests on the assumption that since applicant number 2 is facing serious charges, and that he may, upon conviction, faces a sentence of life imprisonment on the murder charge, the possibility exists that he may flee. It was also argued that border crossings without proper documentation into Lesotho are a frequent occurrence. It must, however, be pointed out that the site should not be loose of the fact that applicant number 2 has a fixed address in Paul Roux. He also has immovable property in the form of a house. The address where he and his family are currently residing has been verified. He does not have a passport and has no family ties outside the borders of South Africa. It is therefore quite clear that applicant number 2 has strong family and emotional ties in the country. Although applicant number 2 has previous brushes with the law, no credible evidence was presented to the court to suggest that he had previously attempted to evade any of his previous trials. I'm of the view that the fear of the investigating officer that he posed a flight risk can be allayed by the imposition of appropriate bail conditions. Furthermore, although it may be argued that based on his previous convictions, the likelihood exists that applicant number 2 may commit further Schedule 1 offences if he is released on bail, I should also not lose sight of the fact that the last conviction for trespassing occurred in 2011, more than 9 years ago. Evidence was also led to the effect that one of the state witnesses received a death threat if he continued to cooperate with the police. Captain Mahlamba testified that he was informed by the said witness that the brother-in-law of applicant number 2 made this threat to the witness via a third person, and that plans are now afoot to place the said witness in a witness protection program. It is evidence of Captain Mahlamba that the intimidation occurred or happened over the past weekend in Pudarichaba at the funeral which the witness attended. Now, from the case record and also from personal knowledge, it was quite clear that during the time of the incident, applicant number 2 was in custody at Kroonstad Correctional Center. Now, therefore, the conduct of the brother-in-law can therefore not be attributed to applicant number 2. Now, if the allegations of intimidation are correct, the court finds it disturbing that the brother-in-law would know the identity of the said witness. As far as I can recall, during this bail application, that the identity of only 2 witnesses were disclosed. Those were that of Pinky, and reference was also made to the girlfriend of applicant number 1. The identity of the witness who apparently had seen the 2 applicants and a third unidentified person approaching from the direction of the farm, as well as the 2 witnesses who overheard the conversation about the attack on a white man in the tavern between the accused and others, were never disclosed during these proceedings. It thus begs the question, who is or was responsible for supplying the names of these witnesses to the brother-in-law. Now, it is so that applicant number 2 deposed to an affidavit in support of his bail application. His evidence would therefore be less persuasive because it was not subjected to cross-examination by the state. So in this regard, S versus Pinar, 1992, Volume 1, SECR 178, Witwatersrand, at page 180, paragraph I. The evidence before the court is that applicant number 2 was seen in the company of applicant number 1, coming from the direction where the farm, where the deceased was killed during the early hours of the morning of October 2. His clothes were wet. During the evening of October 2, he was again seen in the company of applicant 2 at the local tavern. 2 witnesses overheard them talking about how they had assaulted a white man and took his cell phone and wallet. Although applicant number 2 elected not to present evidence on the merits of the case, it was however testified by Captain Mahlamba that during an interview he had with applicant number 2. He provided an alibi witness. That alibi witness was the wife of applicant number 2. Captain Mahlamba then subsequently obtained a statement from the wife of applicant number 2. Now, other than what is currently in the police docket, at this juncture, there is no other evidence that linked applicant number 2 to the commission of the crimes he is charged with. In particular, no direct evidence was adduced to link applicant number 2 to the commission of the crimes. Direct evidence in the sense of eyewitnesses, etc. The results of the DNA swabs that were taken from the inside and outside of the body of the deceased are inconclusive in as far as it relates to him. Now, basically in support of both the applicants, it was further submitted and argued, and with reference to the riot that occurred at court when the two applicants made their first appearance in court on October 6th, it was argued that the release of the applicants would disturb the public order. Now, the approach to this ground in subsection 4E has been discussed in S versus Lamini, Bladla, Hubert, and Skitukat Supra as follows at paragraph 57. I quote, "It is important to note that subsection 4E expressly postulates that it is to come into play only in exceptional circumstances. This is a clear pointer that this unusual category of factors is to be taken into account only in those rare cases where it is really justified. What is more, subsection 4E also expressly stipulates that a finding of such circumstances has to be established on a preponderance of probabilities and between bracket likelihood. Lastly, once the existence of such circumstances have been established, paragraph E must still be weighed against the considerations enumerated in subsection 9 before a decision to refuse bail can be taken. Having regard to these jurisdictional prerequisites, the field of application for subsection 4E and 8 capital A will be extremely limited. Judicial officers will therefore rely on this ground with great circumspection in the knowledge that the Constitution protects the liberty interests of all. Close quotation. Now it must be said that the killing of Brendin Horner has sparked events which opened wounds which in the 26 years of our democracy, I believe, have been left unattended. The events over these past few days have exposed racial tensions, the economic division in this small community, and the mistrust in the South African Police Service. Various sectors of the community came in uprising. Farmers, particularly white farmers, have called for justice and have rebelled against the inability of the police to protect them. They went to the extent of taking the law into their own hand by storming the court building. Demanding the release of the two applicants before court. Now that is a threshold, the crossing of which no court can condone. The black community, in reaction, has pushed back and highlighted the racial abuse suffered in these rural communities. There has been calls from all sectors or spectrums of the community for the court to do what each of them perceive to be justice. Threats have been made of mob justice in an attempt to pressure the court into following their will and ignore its fundamental purpose, that it is there to uphold and protect the Constitution and to dispense justice without fear, favor or prejudice. Now, with regard to the state's case, I have already indicated earlier that it would appear that the state does not have a strong case against applicant number 2. I have already shown that he is not a flight risk and he will also not interfere or intimidate the witnesses. Any fear or apprehension by the investigating officer by the state with regard to intimidation or interference with the witnesses or the possibility that he might evade his trial can be curbed or ameliorated by the imposition of appropriate bail conditions. Court is further of the view that the alleged intimidation of one of the state witnesses cannot be put before the door of applicant number 2, since no credible evidence was advanced that he had a hand therein. I am of the view that I would be failing in my duty as judicial officer to keep applicant number 2 in custody just because his release on bail may cause a public disturbance or undermine peace and security. To keep him in custody under these circumstances would be nothing but a form of anticipatory punishment which our courts have previously warned against. See, in this regard, as with Hutchison, 1991, Volume 2, SA 805, NM, Namibian decision, at page 802, paragraphs A to B. Court is further of the view that the continued detention of applicant number 2 will also be prejudicial to him financially because he will lose his disability grant which he utilized to support his family if he is kept in custody. I am accordingly of the view that applicant number 2 have succeeded on a balance of probabilities that exceptional circumstances exist which justify the release of applicant, which justify his release on bail. In respect of applicant number 1, coming to his position, the court is inclined to agree with the prosecutor that the prima facie case was made out against him. Although there is no direct evidence that linked him to the commission of the crimes, certain facts points towards the involvement of applicant number 1 in the commission of the crimes he is alleged to have committed. In enumerating them, I do not propose to make a provisional finding of the guilt of accused number 1. My task is merely to assess the prima facie case against the applicant number 1. These pointers are: 1. He was seen in the early hours of the morning on October 2 coming from the direction of the farm where the deceased was killed. 2. There is evidence or a statement obtained from his girlfriend that he was not in the house when she woke up at around 2300 hours. And according to the girlfriend, applicant number 1 only arrived home around 4 a.m. that morning on October 2. 4. During the night of October 2, Two of the witnesses overheard him discussing how they attacked a white man on a farm who came to disturb them. One of the witnesses saw him taking out a wallet and a cell phone, boasting that those were the property that he took from the white man. 6, upon his arrest and following a search of his house, 2 pairs of trousers stained with blood were found in a basket in his shed. A pair of shoes with mud and blood stains were also found in his shed and was also confiscated. When the police wanted to search the second shack on the premises, he lied to the police that the shack was locked. He also informed the police that that particular shack belonged to his brother, and the brother left with the keys to Vicksburg. Upon investigation, however, by the police, it was found that the second shack was not locked. Now, the said shack was searched in the presence of applicant number 1. That's now according to the police. And in a deep freezer, the police found a third pair of trousers. This pair was also bloodstained. In court, however, applicant number 1 denied being present in the second shack where the third pair of trousers was discovered. Now, the fact that he lied to the police that first, that the shack was locked, and secondly, he lied about his presence in the shack during discovery of the trousers in the deep freezer, raises a suspicion that perhaps the reason why he behaved the way he did was because he knew that the pair of trousers was hidden in the deep freezer. Perhaps he also knew that the bloodstains on that particular pants that was found in the deep freezer, that those bloodstains was not coming from an animal. Furthermore, if the girlfriend's statement is anything to go by, applicant number 1 has some serious explanation to do as to why his girlfriend would tell the police that he left home in the middle of the night and only returned home the following morning. Now, having considered the evidence before me in respect of applicant number 1, I am of the view that applicant number 1 has failed to demonstrate on a balance of probabilities that exceptional circumstances exist which justify his release on bail. Now, even if I am wrong in this regard, I am also not satisfied that the interests of justice permit the release of the said applicant on bail. Applicant number 1 knows that his girlfriend is a key witness in the case against him. Her evidence will rebut his alibi that he spent the whole night at home on the night the deceased was killed. This created a strong likelihood that, having regard to the relationship between them, that applicant 1 will attempt to influence the girlfriend to deviate from his statement, and that likelihood is the real one. Now, it is quite clear before court, and was also argued to that effect by Mr. Harrington, that the investigation of this case is a complex one and will require some time to complete. Now, most probably, if the court refuses to release the accused on bail, in all likelihood, you will be kept in custody, or you will remain in custody for at least a period of at least more than 6 months or longer before the trial can be finalized. From a personal knowledge, I know that it can take more than 6 months, even longer than a year, to await results or DNA results from the forensic laboratory. And it will also appear that there's a backlog in finalizing DNA reports. It would, however, appear that this case enjoys priority. But before I state that, I also need to mention that because of the fact that you will remain in custody for longer than 6 months, most probably you will suffer financial difficulties owing to his detention. Therefore, it is the request of the court to the state to try and expedite this matter, I would also call upon the Minister of Police, and I believe he was here at the previous occasion, not to use undue influence, but to use the influence of his office in ensuring that this matter is finalized as speedily as possible, so that the accused before court can be brought before court, and that their right to a speedy trial be honored. A speedy finalization of this matter will also, I believe, instill confidence in the criminal justice system. That is the hope that I have. Now, having considered all the evidence before me, the court is of the view that the application for bail in respect of applicant number 1 is hereby refused, and in respect of applicant number 2, his application for bail is granted. He's accordingly entitled to be released on bail.
As a court, please. As a court, please.
Mr. what's going to happen to the case?
Bishop, I am going to ask for a remand for further investigation in the matter. May I suggest the date of 1 December, that is a Tuesday. I have confirmed that this court is in session here on that day.
Well, it's supposed to be a Paul Roux matter. I don't know, and normally Wednesdays are Paul Roux days.
Bishop, I would submit a request that we keep the matter here, based on the security issues that is at hand. Can we not keep it here?
Well, I think for security reasons, it would appear that this is basically Paul Roux is a periodical court, and that it is best for the matter to remain on the
Senekal.
Not necessarily on the Senekal role, but it stays or remains. Yes. Okay.
Is the date of the first hearing suited?
Let me hear from.
May is the court, Your Worship, before I can deal with the aspects of the date and the forum where the matter has to be held going forward. There is one omission, Your Worship, that I noted in the judgment with regard to the second stage of bail, dealing with the amount of bail.
Well, I'm gonna, when I postpone the matter, I will set down in terms of, because of the
As a purposes.
amount suggested by applicant number one in terms of it is.
As a court cases, Your Worship. Your Worship, with regards to the proposed date of the 1st of December 2020.
And by the way, just I intend to set bail in the amount of at least 5,000 rand for his release. But anything else?
Your Worship, in respect of the date, is suitable.
Yes.
And the matter can be postponed to this court as a court basis.
Chief, can I just speak to the issue of the date? The court aware that this was a judicial matter from the legal matter. And since the bail is being disposed of, obviously there are processes that needs to be followed. So I want to place it on record at this point in time that I may not be present the date that will be postponed until all the paperwork administration has been sorted out between myself and the legal team. But beside that, on the 1st of December, by the matter and High Court in Bloemfontein. So I won't be where it's Senekal. So I want to place this on the regular.
But before I release you, I would like you to explain to applicant number one the remedies available to him in terms of he can appeal the judgment of the ruling of the court. Alternatively, if new facts arise during the course that may impact or may, if new facts arise, that he may approach the court with another bail application on new facts.
On new facts, yes.
Just would like you to explain that to him as well, that he is aware of that right.
Would the court want me to do it now while the proceeding?
Well, perhaps when we adjourn, I don't think there's any other matter on the road, okay? So, after I postpone this matter, I will adjourn the court as well.
You just one aspect, Mr. Mutu, just listen to me now. In terms of the legal aid regulations, since I've done the bail, I was given an instruction. I'll have to continue with the matter. So therefore, it means I'll still be revisiting accused number one. So if everything then goes well after I've explained things, even if I'm not here on the first, I'll make arrangements with my legal.
Mr. Mutu, I believe we'll take good care of your client in your absence.
As a court basis.
The 1st of December, no?
Can I approach one of the court judges? Can I approach him?
Gentlemen, the matter is postponed until the 1st of December 2020 for further investigation. Accused number 1, in custody, your bail has been denied. Accused number 2, in custody, bail is set in the amount of 5,000. Upon payment of the said sum of money, you shall be released from custody on condition that 1. You appear personally at each and every court date and times and to such places in which these proceedings are adjourned until a verdict is given in respect of the charge to which the offences in this case relates, or where the sentence is not imposed forthwith after verdict and the sentence extend bail until sentence is imposed. Do you understand that?
Somehow you may have to shut down one head and then by the ones that I said, you want to move measuring head. So I paid in the moment, and I had to get up when they say, they could go ahead and so high. So baby and I had the guns up when they say, the hotel had a man, a baby more, baby man, get it down with a go for that moment. The girls are high giving. I live there, a pair of your overhead. We put on the side of coaching, letting the lady and singing the city on the head, the hotel and landing there, sitting in our
Okay.
Understood?
Okay. Until the conclusion of this matter, the court orders that you report every Monday, Wednesday and Friday between 8 in the morning and 1700 hours at the Paul Roux police station. You understand that?
I didn't know anything to a movement. Even highway road, you can take a man. They had a way down here. We keep what I have on station near Paul Roux, Kamanta, Labrado, Laxano, Hore, Yago, eat yourself, like a 5 feet.
You are further ordered not to have any communication or contact with the witnesses for the prosecution, either directly or indirectly.
Where's a happy over here? How I can't tell over here. Who can come on? Some people of fame, about fame, and people say, we can see someone over enough. Where is all like them? Muhala, Kabaya, Inka, Omela, or
Mr. Matlaletsa, court would further like to advise you that if after your release on bail, you fail to appear at court on the date and at the time appointed for your trial or to which the proceedings are adjourned, or fail to remain in attendance at such trial or such proceedings, or fail to comply with any of the above conditions, the court shall declare your bail provisionally forfeited or cancelled, and the money provisionally forfeited to the state, and issue a warrant for your arrest. Do you understand that?
the highway over here, when I have Ukasi, Matahi, Pedro, Capalipero, anyway, they said on the hotel with John and home, whichever over here, Uka wants to more of some room in here, Uka was a other quarter, Yava here, Chantia, Bailey, and more Asia, and one ahead, two moves and more wearing a winner, coming up with more
Can you afford to forfeit the 5,000 rand if you decide to pay the bail?
I will do on the corporation how we finish the 5,000 rand. If you government gives any to collection, take it.
Then you have to adhere to the bail conditions, okay?
We know how fellow over here, like the little mamela and pay.
So let's conclude the roll for the day.